Recording in progress. Recording stopped. Recording in progress.
Good morning, everyone. Good morning and welcome to the meeting. Today we'll be having the State Security Agency to make a second round presentation in relation to the RCA bill. That was remitted by President to back to Parliament. We can note that the minister or in the presidency has apologized for not coming to the meeting. We have an apology of Mr. Oscar Matafa as well. Committee Secretary, do we have any further apologies?
Good morning, Chair. Another apology from Mr. Tsodis.
Thank you. That's noted. Can you confirm if the SSA is in the meeting?
I confirm that they are in the meeting.
Who is leading the delegation?
Chair, can you ask them to indicate who's leading them? I see that there's somebody from the DG's office, but I don't know if it's the DG.
SSA, can we see you?
Good morning, Chair.
Good morning, how are you?
All right, my name is Kumbola Masinge. I'm the director from the OIC. We have the acting DG, Mr. Ramabulan. I think he is just getting ready to, he's leading the delegation.
Acting DG. Mr. Ramabulana, you seem to be muted.
Acting DG is muted. What I'll do, I'll just call the staff officer there to assist with the process quickly.
No problem.
Yes. No, yeah. Okay. Are you saying computer?
Acting DG, you're muted now. You can unmute.
Okay, Kumbula, good morning.
Good morning, Acting DG.
Good morning. My apologies for the delays. I got some glitches on the system. As the State Security Agency,
Acting
let
DG.
me first come in. Can you hear me?
Yes, we can hear you. Can
Yes.
you start with if there is any particular reason why we only receive the presentation at the doorstep of the meeting?
Oh yes, our minister, I was going to actually explain that. Firstly, our minister was in Addis Ababa, so we needed to actually get her green light in terms of circulating the document, the presentation, because these are matters of legislation and policy, which are the preserve of the minister. So we only got a green light from her today, but secondly, she actually gave apparently an apology or forwarded an apology yesterday, as I'm told. We profusely apologize for actually circulating the document and the presentation late. It was out of the fact that the minister had not given us a green light at the time.
That's fine, Acting DG, you can proceed.
Yes, with the apology tendered, Chairperson, let me indicate I'm leading the delegation. Let me indicate first and foremost that our legal expert, Ms. Alfredine Jenica, will actually be giving the presentation. As an opening, I consulted with the minister and we agreed that ours for today particularly is to confirm our support for the president's application to deal with or address the lacuna in terms of the operation of the RICA Act, and also to really provide our insight in a strategic way into the matter in preparation for any eventuality of returning the matter to Parliament, so that at least we are on the same page with members of the Portfolio Committee and everyone involved. I must say we are going to at least bring into confidence the committee on our side of how things should actually be handled or how things should actually pan out. And Alfredine will actually assist. I will also be there to provide answers where the committee wants us to provide answers to. Without wasting time, let me then ask one expert and the other colleagues that are part of my delegation to proceed.
You can proceed.
Good morning, Chairperson and members. My name is Alfredine Jenica, and I'm the Special Advisor in the Office of the Director General.
Can we see you, Special Advisor?
I've been trying to do that, Chairperson. And oh, I think I'm working from my laptop, so my laptop is not showing the video. Sorry, Chairperson. At best, what I could do is I've been trying to load a picture.
Or maybe showing the face is a security risk.
That too, Chairperson. That too. If I do manage I do have a picture. Yes, thank you. Chairperson, our presentation today will, in the main, focus on the questions you asked us last Tuesday. You asked us to amplify what are the national security imperatives and to clarify what that means in the context of the presentation by the Department of Justice and Constitutional Development.
Not a special advisor. Are we then able to flight the presentation?
The presentation was sent to the Secretariat of the Committee, Chairperson. Could I ask them to flight it?
Mr. Ramano, can we flight the presentation?
No, Chair. It's best if they share the presentation themselves, so that they will be in charge of it. And
have you given them co-host rights?
yes, I have.
So, okay. Chairperson, with your permission, I have not done this before. Can you just give me a moment to please see how one does that? Chairperson, thank you for bearing with me and for the assistance from my colleague, Mr. Masinge. First of all, we'd like to say we thank you for this invitation to the committee. We think it's critically important for the agency to be able to justify and amplify to you why the national security requirement in section 25 capital A 2B is so important. The presentation that I'm about to give is with the collaboration between the State Security Agency and the Office for Interception Centers. You will recall that the Office for Interception Centers is established in terms of RICA itself, the Regulation of Interception of Communications and Provision of Communication-Related Information Act. So what we hope to achieve by this meeting is that we first of all, we are supporting the presentation delivered by Department of Justice and Constitutional Development. And in addition, we seek to clarify the necessity of the national security considerations in section 25 capital A 2B of the bill, and to amplify how the insertion of that subsection impacts the work of the agency in the performance of its legislative mandate. Lastly, we discuss the justification for the retention of that subsection to ensure the efficacy of the interceptions for counterintelligence purposes. It is our sincere hope that we can assist the Portfolio Committee in its deliberations and to contribute to the refinement of the bill in alignment with constitutional principles and cognizant of national security imperatives. With regards to the national security imperatives, what will follow is a discussion on the assessment of how RICA, the RICA framework, is essential for safeguarding national security and enabling the work of intelligence and law enforcement agencies. Secondly, the implications of post-surveillance notification for the agency will comprise an evaluation of how the proposed notification requirements may impact intelligence operations, confidentiality, and overall effectiveness in surveillance activities. And thirdly, the impact of the legislative lacuna created as a result of the delays in the enactment of the bill. We will review the legal and operational challenges created by the delay in implementing the bill, particularly its impact on ongoing security and intelligence operations. By way of background, Chair, we just want to state that subsequent to the Constitutional Court judgment in Amabungani Center for Investigative Journalism and the Minister of Justice, the agency participated in the legislative review undertaken under the leadership of Department of Justice and Constitutional Development. The bill was subsequently passed by Parliament on the 6th of December 2023 and submitted to the President for his assent in the same month. The President, His Excellency Mr. M.C. Ramaphosa, elected to return the bill, citing concerns with the constitutionality of the bill. Those concerns are set out in his letter to the Speaker of the National Assembly dated the 15th of November 2024, wherein he states that decisions in terms of section 25 capital A 2B may lead to the subject of surveillance never being notified of the surveillance and no review being possible of a decision in terms of section 25 capital A 2B to indefinitely suspend post-surveillance notifications obligations. Secondly, the continued failure to adequately provide safeguards to address the fact that interception directions and notification suspensions applications are sought and obtained ex parte. The Portfolio Committee consequently requested a legal opinion from the Parliamentary Legal Advisor by the 14th of February 2025. A comprehensive review of RICA is underway by the task team, as I said, by the task team led by Department of Justice, with the participation of both the agency and the OIC. There's also a contemporaneous application that's been brought by the President in the Constitutional Court seeking an order pending the curing of the legislative defects in RICA. Importantly, the submission that the President makes in his founding papers is that without a designated judge, RICA would be substantially inoperable. This is presently the case. The effect is that South Africa's national security may be compromised. He states further that the agency has confirmed its concern that it is at serious risk of losing critical targets who are involved in syndicates and terrorism, and that without the ability to obtain interception directions, enforcement agencies have no ability to detect serious threats of civil unrest. Secondly, that without being able to obtain interception directions, it will be unable to detect and prevent events that pose a risk to South Africa's national security. The President therefore seeks an order for just and equitable relief, which in respect of Section 25, capital A, post-surveillance notification is as follows. He is requesting that within 60 days of the date of expiry of a direction or extension thereof, in terms of Sections 17 to 21 and 23, whichever is applicable, the applicant that obtained the direction, or if not available, any other law enforcement officer within the law enforcement agency must notify in writing the person who was the subject of the direction, and within 15 days of doing so, inform the designated judge, the judge of a high court, a regional court magistrate, or a magistrate. Secondly, if the notification referred to in subsection 1 cannot be given without jeopardizing the purpose of the surveillance, the designated judge, judge of the high court, a regional court magistrate, or magistrate, upon application by a law enforcement officer, may direct that the giving of a notification in that subsection be withheld for a period which shall not exceed 90 days at a time or 2 years in aggregate. The agency has abided in the President's application, but has subsequently been directed to file return submissions. Importantly for our discussion today is the fact that the bill provides also in subsection 2B that where there is a potential to impact negatively on national security, a designated judge may, upon application by a law enforcement officer, direct that the giving of notification be withheld for such a period as may be determined by the designated judge. Chairperson, it is our view that subsection 2B should be retained. And our motivation or our justification for that is essentially that if we discuss the national security imperative, our view is that this is adequately covered in the Constitution and in legislation. The Constitution itself sets out what are the governing principles of governing national security. And that's set out in Section 198 of the Constitution, which provides as follows: that national security must reflect the resolve of South Africans, as individuals and as a nation, to live as equals, to live in peace and harmony, to be free from fear and want, and to live a better life. The resolves to live in peace and harmony precludes any South African citizen from participating in armed conflict nationally or internationally, except as provided for in terms of the Constitution or national legislation. C. National security must be pursued in compliance with the law, including international law. And D. National security is subject to the authority of Parliament and the national executive. The national security imperative is the responsibility of the nation as a whole. It's not the exclusive responsibility of government, nor the sole preserve of the security services. The security services as defined in terms of Chapter 11 of the Constitution. While maintaining national security, the security services work in collaboration with the public and private sector, with foreign governments, and citizens and non-citizens alike. National security is pursued in compliance with the law, subject to the authority of Parliament and the national executive. The constitutional imperative is to fulfill the state's responsibility to uphold the rights of all the people in the country and affirm the democratic values of human dignity, equality, and freedom in Section 7 of the Constitution. The following rights are relevant for our discussion: the right to equal protection and benefit of the law in Section 9, subsection 1 of the Constitution, the right to life in Section 11, the right to freedom and security of person, including the right to be free from all forms of violence from either public or private sources, in Section 12(1)(c) of the Constitution. The right not to have their person or home searched, their property searched, their possessions searched, and the privacy of their communications infringed, in Section 14. The National Strategic Intelligence Act of 1994 sets out the legislative mandates of the security services and directs the work of the national intelligence structures. And once again, Chairperson, I want to draw the distinction here that national security does not equate to intelligence. There seems to be a conflation with regards to that when the terminology national security is heard, it automatically implies intelligence. The security services of our country, as the Constitution provides in Chapter 11, covers, yes, the Civilian Intelligence Service, but it also covers the South African Police Service and the South African National Defence Force. That very same act, the National Strategic Intelligence Act, which I alluded to, defines what national security is as follows. It says that national security includes the protection of the people of the Republic and the territorial integrity of the Republic against A, the threat of use of force or the use of force, B, the following acts. 1, hostile acts of foreign intervention directed at undermining the constitutional order of the Republic. 2, terrorism or terrorist-related activities. And 3, espionage. 4, the exposure of a state security matter with the intention of undermining the constitutional order of the Republic. 5, the exposure of economic, scientific, or technological secrets vital to the Republic. 6, sabotage. And 7, serious violence directed at overthrowing the constitutional order of the Republic. C, these acts directed at undermining the capacity of the Republic to respond to the use or the threat of force, the threat of the use of force, carrying out of the Republic's responsibilities to any foreign country, and international organizations in relation to any matters referred to it in this definition, whether directed from or committed within the Republic or not. But national security does not include lawful political activity, advocacy, protest, or dissent. The business of counterintelligence, which is set out in the National Strategic Intelligence Act, also is articulated in the definition of counterintelligence in the National Strategic Intelligence Act of 1994. And he defines counterintelligence as measures and activities conducted, instituted, and taken to impede and neutralize the effectiveness of foreign or hostile intelligence operations, to protect intelligence and any classified information, to conduct security vetting investigations, and fourthly, to counter any threat or potential threat to national security. This definition, therefore, includes espionage, sabotage, terrorism, a range of serious violence aimed at overthrowing the constitutional order of the Republic, such as the destruction of critical installations or resources of the Republic. When developing the National Strategic Intelligence Act, this very legislature had envisaged or anticipated the manifestation of hostile activities by foreign intelligence services and other intelligence actors, the theft of intelligence and any classified information, potential blackmail, compromise, undue influence, and manipulation of government officials in strategic areas, and or assigned to deal with intelligence and any classified information, the manifestation of sabotage, terrorism, and violence aimed at overthrowing the constitutional order of the Republic. The same legislature entrusted the national counterintelligence responsibility to the agency and envisaged that the agency will develop the requisite capabilities, capacities, and an operating model to counter, impede, and neutralize hostile actions by foreign intelligence services and actors involved in manifesting sabotage, treason, terrorism, and threats to national security aimed at or against strategic installations and the resources of the Republic. Equally, The agency is expected to institute measures to protect intelligence, classified information, and strategic installations and the resources of the Republic. To be equal to this task, the agency must determine the locale of intelligence and any classified information, strategic installations, and the resources of the Republic. It must determine the extent of and implications of any action aimed at or against such intelligence and any classified information and the strategic installations and resources. The agency therefore requires a comprehensive knowledge about adversaries in order to inform the design, development, and implementation of the requisite security solutions or safeguard mechanisms. The State Security Agency executes the role of counterintelligence coordination in the country through the Counterintelligence Coordinating Forum that is created by ministerial directive. The role of the CICF is to coordinate the compilation of a national CI threat picture, joint operations, and the development and implementation of countermeasures, including monitoring adherence to implemented countermeasures. Secondly, the development and review of CI-related legislation, policies, regulations, directives, strategies, and standard operating procedures. The CICF's membership is constituted by the agency as the lead department and divisions of SAPS and defense that are assigned with CI-related functions, as well as any other departments that are co-opted to contribute to the execution of the national CI mandate, and these include, for example, the Department of Home Affairs and the Border Management Agency. The State Security Agency, working with all other departments, continues to steer the national CI mandate to deploy resources and capabilities in the measures and activities conducted, instituted, and taken. Firstly, to impede and neutralize the effectiveness of foreign or hostile intelligence operations. Secondly, to protect intelligence and any classified information. Thirdly, to conduct vetting investigations. And fourthly, to counter any threat or potential threat to South Africa's national security. The functions of CI are therefore primarily related to four tasks. I'll start with espionage. Firstly, which involves threats of foreign or hostile intelligence operations emanating from or sponsored by foreign intelligence services or their front entities, taking deliberate actions to undermine the sovereignty of our country, to gain unauthorized access to classified vital information of the state and its strategic capabilities, as well as subverting its growth potential and competitiveness of its products and services in global markets. These actors and their front entities have been complicit in exerting undue influence and manipulation of government officers deployed in strategic areas or positions of influence. The hostile actions include orchestrating acts of espionage and abusing diplomatic privileges as a means to camouflage foreign and hostile intelligence operations. The purpose behind espionage is to gain unauthorized access to and steal classified, privileged, and sensitive information belonging to our country as part of aiding the country of origin so that it can maintain sustainable competitive advantage over us. Through the skillful deployment of South Africa's counter-espionage capacities, coupled with their agility and responsiveness, hostile intelligence machinations sponsored by foreign intelligence services were in many instances exposed, thwarted, or neutralized. Through responsive counterintelligence activities, the country has been able to protect its intellectual property rights, privileged policy and proprietary information, and classified information pertaining to cutting-edge technologies. You will recall, Chairperson, the incident regarding the theft of the Mokopo missile blueprints from Denel between January 2008 and 2009. It is well recorded. It is, in fact, you can find a reference to it on the Al Jazeera platform. As a result of the counterintelligence investigations by the national security structures, two accomplices, one Dani Steenkamp and Anthony Viljoen, were convicted under the Protection of Information Act of 1982. Viljoen also pleaded guilty to the contravention of the National Conventional Arms Control Act. of 2008. A third accomplice, Johann Grundling, who traveled with them initially to Israel to sell the missile plans, committed suicide in March 2010 and therefore escaped a conviction. The second task of counterintelligence relates to the protection of intelligence and any classified information. Now, national security intelligence is defined in the National Strategic Intelligence Act of 1994 to mean intelligence which relates to or may be relevant to the assessment of any threat or potential threat to the security of the Republic in any field. In this regard, the agency has had some success in successfully interdicting the publication of classified material in as far back as 2008 in the matter of National Intelligence Agency versus Business Day Financial Mail publishers. After it conducted a counterintelligence investigation into the unauthorized disclosure of classified information. In that regard, the Johannesburg High Court had ordered that the Business Day Financial Mail publishers not publish a document or any part thereof. Secondly, that no other person is entitled to be in possession of the document or publicize the contents without the authority and permission of the agency. Thirdly, all copies of the document to be returned to the agency immediately, and that the Business Day and Financial Mail pay the costs of the application. The third task of counterintelligence relates to vetting investigations. It is part of and associated with the role of security competence testing, and it contributes to efforts to create conditions of security in client departments or state-owned enterprises that necessitate that security competence tests are conducted on personnel deployed to sensitive positions who will from time to time gain access to, deal with, and process vital information of the state and restricted areas of departments or state-owned enterprises. This includes access to and protecting very important persons, institutions, or places that are declared as critical infrastructure. This is critical for that vital information of the state, VIPs, critical infrastructure, assets, and the resources of the country will be secure in the care of a person with proven and tested security competence. The fourth task of counterintelligence relates to threats to national security. And these include acts constituting sabotage, which are aimed at or against critical installations or the resources of the Republic, terrorism, and any other criminal acts of serious violence directed at overthrowing our constitutional order. This responsibility contains acts which are aimed at or against. In other words, for you to warrant CI interventions such as subversion, terrorism, sabotage, and terrorism must have been aimed at overthrowing the constitutional order of the Republic. And to be effective in this regard, the agency must develop knowledge about the nature of the threat and determine the installations or resources, including the location of classified information, that must be protected against that threat. South Africa is under increased international scrutiny following the findings of the Financial Action Task Force mutual evaluation in 2018, which resulted in the country being placed under increased monitoring on the so-called FATF grey list in February 2023. Despite concerted efforts by all of government to address the many structural deficiencies identified to enhance its effectiveness to counter money laundering and terror financing, and to exit the grey list in March 2025, indications are that FATF remains unconvinced that sufficient progress has been made, notably by law enforcement agencies, to identify, investigate, and prosecute cases. A critical challenge remains the inability to identify, investigate, and collect evidence of criminal suspects' plans and activities, networks, domestic and abroad, means of support, etc., that has been made possible, that has been made impossible since the Constitutional Court decision in Amabungane and the non-finalization of the review of RICA. The Constitutional Court in Amabungane found that the notification of such subjects of interception, irrespective of whether they threaten our national security, must be given within 90 days and that it may be extended up to an aggregate of 2 years. It is the agency's submission that this poses a real risk that the objective of counterintelligence and its countermeasures to neutralize hostile actors will be defeated. The planning and operationalization of countermeasures discussed above generally take place over a long time horizon, beyond 2 years. And the activities that threaten national security are frequently transnational in nature. The recruitment of sources and the infiltration of assets into criminal and terrorist networks takes several years to cultivate. The notification to subjects of the surveillance, even after the fact, would not only compromise the efficacy of countermeasures in South Africa, but also compromise the efficacy of the work of foreign agencies, which may have taken years to cultivate. The disclosure is likely to compromise the lives of our assets and their families, as well as law enforcement and intelligence agents. In espionage cases in South Africa, the post-surveillance notification to a foreign agent would compromise international relations and diplomacy. The requirement, therefore, for post-surveillance notification to targets involved in contravention of national security annuls the agency's execution of its legislative mandate that is set out in the National Strategic Intelligence Act, which I have just discussed. When the President made his submissions to the Constitutional Court in December 2024, the President alerted the Court to the fact that he seeks supplementary, just, and equitable relief to address the dislocation of our surveillance system. He says that until such time that Parliament has reconsidered the RICA Amendment Bill, and the President takes time in terms of Section 79(4) of the Constitution, it will not be possible to engage in interception necessary to protect the nation's security and comply with South Africa's international law obligations. The lacuna in law owing to the delay in the enactment of the bill has effectively resulted in the agency losing its ability to utilize intrusive means as directed in law and regulated through the authorization by the designated judge in terms of RICA and its operational protocols. The security implications of not utilizing interceptions and surveillance during the agency's counterintelligence operations are the following. I'm going to go through these briefly, Chairperson. The first one is that we must anticipate an increased risk of terrorist activities and attacks. With regards to unmonitored planning, terrorist groups could plan and coordinate attacks without detection, increasing the likelihood of successful operations. Since we would lack an early warning, without intercepting their communications, security agencies may miss critical early warnings of impending attacks, leaving populations vulnerable. The second impact is reduced intelligence gathering. There will be limited insight as a result of not having the surveillance capabilities. Intercepted communications are a primary source of intelligence on terrorist networks, including their structure, members, and operational plans. Without this, agencies may lack crucial actionable intelligence. We'll be unable to disrupt networks. Intelligence from communications is often used to identify and dismantle terrorist cells, funding sources, and supply chains. Failure to intercept communications could allow these networks to grow and operate unchecked. The lacuna in laws would already result in weakened counterterrorism efforts through ineffective prevention and challenges in tracking threats. And fourthly, with regards to global security implications, which I alluded to, there would be an increase in cross-border threats and weakened international cooperation. Because without the valuable data which we would be able to obtain from interceptions, international counterterrorism efforts may suffer. There would be concomitant public safety concerns with a loss of public trust and increased fear and instability. It also poses ethical and legal dilemmas for law enforcement and for intelligence. We're trying to balance the right to privacy and national security. And while intercepting communications raises privacy concerns, not doing our interceptions may compromise national security. It's therefore critical that we strike a right balance. I would go so far as saying, Chairperson, that we're not only striking a balance between the right to privacy and national security. In fact, it entails the balance between the right to privacy and the right to freedom and security of person, which includes the right to be free from violence, whether from public or private sources. 7, there are technological challenges which the agency and other law enforcement agencies contend with regards to encryption and anonymity. Terrorist groups increasingly use encrypted messaging apps and anonymized technologies, making interception more difficult. Not addressing these challenges can leave security agencies at a disadvantage. Moreover, terrorist groups constantly evolve their communication methods. Without interception capabilities, agencies may struggle to keep up with these changes. There are technological and cyber implications as well. Terrorist groups are increasingly leveraging emerging technologies such as blockchain, cryptocurrencies, and decentralized communication platforms. Without interception capabilities, security agencies may struggle to monitor these activities, allowing terrorists to fund operations and communicate securely. With regards to cyber terrorism, the terrorist groups may use unmonitored communications to coordinate cyber attacks on critical infrastructure such as power grids, financial systems, or healthcare networks. The inability to intercept such communications could leave the country vulnerable to devastating cyber incidents. Terrorist groups could also use AI-driven tools to automate recruitment, propaganda dissemination, and attack planning. Without intercepting these communications, it becomes harder to counter the use of advanced technologies. There are geopolitical consequences. Of course, the main ones here are the erosion of our sovereignty, strained international relations, and proxy wars and state sponsorship. With regards to the societal and psychological impacts, terrorist groups often use unmonitored online platforms to radicalize individuals and recruit new members. Without intercepting these communications, it becomes harder to identify and counter radicalization efforts. There's also the spread of propaganda and polarization and division. As successful terrorist attacks can exacerbate societal divisions, fuel xenophobia, racism, and political extremism. This can lead to further instability and undermine social cohesion. There are economic consequences. Of course, there's a direct cost of the attack and also the impact on tourism and trade. And then lastly, there's the long-term strategic implications, the loss of our strategic advantage as a country. Intercepting communications provides a strategic advantage in understanding terrorist tactics, techniques, and procedures. Without this advantage, security agencies may fall behind in the evolving landscape of terrorism. There would be the proliferation of terrorist networks, because unmonitored communications can facilitate the expansion of the terrorist networks, enabling them to establish new cells, recruit globally, and share resources. And then, of course, there goes with us the legacy of instability. Failure to intercept communications and prevent attacks can create a legacy of instability, particularly in regions already vulnerable to conflict. This can perpetuate cycles of violence and hinder long-term development. Now, Chairperson, I don't have to point out that we have had just across our border in Mozambique, we have had instances of terrorist attacks over the last 4 years. And we must be mindful that this threat is in fact very close to home. And there have been instances too recently reported in the media where there have been individuals arrested for terrorism activities as well as for terrorism funding activities. An example of how the security implications play out in practice. which we have to deal with daily as the agency, is that in the case of counterterrorism, information would be obtained through our own investigations or shared by international counterparts, which would refer a terror suspect, which would refer to a terror suspect in South Africa or abroad, utilizing a South African RICAD SIM card and who is part of a terror network and may even be implicated in or planning a possible attack. With the situation that we currently find ourselves, we would be unable to conduct a real-time investigation to confirm or refute such a threat. And we would even be unable to identify the user of that SIM card. Follow-up investigations on such number in most instances, on such a non-RICAD number in most instances, indicate an individual in whose name the SIM card was originally registered, and often fraudulently or in bulk through criminal networks, with no trace on who the current user is. Another reality is that the terror suspect utilizing a particular number may have illegally acquired a South African pre-RICAD SIM card that is active elsewhere, but is not even active or registered on the South African communication networks. And thirdly, this inability renders the agency not only ineffective in fulfilling its counterterrorism mandate, but presents increasing reputational and security risks to the country, increasingly identifying South African links to international and terror networks. The rigorous compliance of interception and monitoring is only applicable to law enforcement agencies, whilst non-state actors, including our foreign counterparts and business competitors, utilize available software to with impunity monitor and investigate citizens in the country. Threats of this illegal and unauthorized access is evident from our intelligence liaison with our foreign counterparts on registered targets. With regards to the Office for Interception Centers, can I just hand over to my colleague, Mr. Masinge, to explain what is the mandate of the OIC and what impact the delay in passing the RICA bill has had on the OIC and or the country.
No
Thank
problem.
you.
Mr. Masinge, you may proceed.
Good morning, Chair, and thank you for the opportunity. As the OIC is established in terms of RICA, and its primary mandate is to facilitate lawful interception on behalf of law enforcement agencies, which include your police, defense, SSA, and other entities that might require the services of RICA. The delay in passing RICA bill impacts OIC in the country as follows. Firstly, it's a basic limitation in terms of the operation. Since the OIC relies on the interception direction signed by a designated judge for it to execute its legislative mandate. Since it is currently impossible to appoint a designated judge, since there is lacuna in law, no lawful interception can take place. The absence of a designated judge and the inability to process interception requests create uncertainties in lawful interception procedures, which may potentially lead to legal challenges, dismissal of cases, and unsuccessful prosecution. May I request you go to the next slide? Thank you very much. The second point basically is the compromised national security, which actually leads to an increase in criminal activities. Ms. Alfredine has already touched in detail in terms of national security. Without interception capabilities, law enforcement agencies lack an essential tool to combat serious crimes such as terrorism, organized crime, and civil unrest. This creates a security vacuum, exposing the nation to heightened risks. The inability to monitor and intercept communication of criminal syndicates may lead to increased illicit activities as enforcement agencies are able to act preemptively against threats. Criminals, including those involved in terrorism, and organized crime may exploit the gap in surveillance to evade law enforcement detection. The last point is that the failure to meet international obligation. The example that was shared in terms of the example case where you have a SIM card registered in South Africa, but conducting activities outside can actually bring the element of the cooperation with the counterparts. So this may actually, this failure can lead to us failing to meet the international obligation. South Africa is bound by international treaties and obligations to provide mutual legal assistance in criminal matters. The inability to facilitate lawful interception due to a legislative delay places the country in breach of its international obligation and potentially leading to diplomatic and legal persecution. I think this is the part that I needed just to cover. I will just hand over to Ms. Alfredine again, just to deal with the recommendation and from there conclude the matter. Thank you.
Thank you.
Thank you, Mr. Masinge. Chairperson, our recommendations as the agency and the OIC are that in addition to the recommendations made by Department of Justice and Constitutional Development, we would argue for the retention of Section 25 capital A 2B in the bill, because in our view it is necessary for the state to maintain national security. Secondly, the national security imperative, which is articulated in Section 25 A 2B, is necessary for the protection of, promotion, and fulfilling the right to equal protection and benefit of the law, the right to life, and the right to freedom and security of person, which includes the right to be free from all forms of violence from either public or private sources. Thirdly, in discussions with the former designated judge, the judge agreed that an application for exemption from the post-surveillance notification requirement need to be submitted to and authorized by the judge. The designated judge would rule on the feasibility and risk of disclosing to the interception subject that he or she was intercepted based on a sound motivation submitted by the agency, supported by the information obtained during the interception. So once more, as our colleague said from Department of Justice, Ms. Pillay, it would be up to the agency to motivate to the judge that on a sound motivation, that the feasibility and risk of disclosing the information that an interception was conducted on the subject would counter our efforts at counterintelligence. In this way, the security imperative would be weighed against the legal imperative of disclosure, and a decision made by the designated judge may overrule the notification requirement. The designated judge should then make the order whether or not to notify the interception subject, and that the appointment of a tribunal, our view is that the appointment of a tribunal to consider post-surveillance notifications would present an unnecessary disclosure of sensitive information and therefore pose additional security risks. We are in favor of a complete review of the RICA legislation, and our submission is that it's necessary to ensure that adequate control measures and regulations are included in law to firstly prevent the illegal utilization and exploitation of South African SIM cards, and secondly, to allow for law enforcement agencies to monitor and investigate individuals suspected of committing serious crimes that impact the safety and security of all citizens. It should become imperative for service providers to conduct a know your client regime of users. And when numbers are transferred or taken off the South African networks, those numbers are blocked. The only way to ensure this is to build a penalty, to build into the legislation a penalty for service providers. In conclusion, Chairperson, the failure to intercept terrorist communications specifically has far-reaching implications affecting national security, global stability, the economic well-being of our country and others, and societal cohesion. While interception raises ethical and legal questions, the risk of not doing so are profound. A balanced, technologically advanced, and internationally coordinated approach is essential to mitigate these risks and protect public safety in an increasingly complex threat landscape. While there are valid concerns about the right to privacy, the failure to intercept terrorist communications can severely compromise national and global security. Effective counterterrorism requires a balanced approach that respects individual rights while ensuring the ability to detect and prevent threats. Government and security agencies must invest in advanced technologies, legal frameworks, and international cooperation to address these challenges effectively. Thank you, Chairperson. I'll leave it to Mr. Ramabulana, our Acting Director General, if he wishes to add anything.
Thank you, Acting DG.
Thank you very much, Chairperson. I think I need to underscore, firstly, or reiterate what our presenter indicated, but to underscore, firstly, the point that national security is the responsibility of all South Africans. Government departments, state-owned enterprises, civil society organization, advocacy group, everyone has a responsibility. And therefore, all of us are actually expected by the Constitution as provided for in Section 198 to do everything in our power to ensure that national security is maintained. And I think, Chairperson, you will allow me, if you wish, to really just demystify this notion in South Africa that national security is the preserve of security agencies or intelligence agencies. It is not. And the goals of national security are supposed to be or are shared by all of us. One, national security is maintained in order to guarantee the existential continuum of South Africa or the South African state, existential continuum of the South African state. And secondly, to articulate and express the reason of the South African state, because every country or every state in the world has reasons, and that are in actual fact codified in their national interest documents or doctrines. And thirdly, national security is meant to actualize the resolve of South Africans, which is actually articulated very clearly in the Section 198 of the Constitution, which says national security must be conducted as the resolve of South Africans individually and as a nation, to at least ensure that we are all equal and that we all live in peace and harmony. We are prevented from fear and want, and we are in a position to live a better life. So these three things must be underscored when we are talking national security. These are the three goals. And the goal of intelligence, different from national security, is to assist government, which is an active agent of the state, to assist government to exercise control over threat and risk, including opportunities, which therefore makes national intelligence or intelligence subordinated to national security. So this is what I want to believe has actually persuaded the lawmakers in 1994 to provide the agency. At the time it was National Intelligence Agency, and now it's the State Security Agency, domestic structure, with a mandate to conduct and coordinate counterintelligence. Now, when you conduct and coordinate counterintelligence, it becomes a continuous thing, not like in or similar to investigations that are conducted by the police where charges are preferred against a person. Here we are talking continuous monitoring, because it is believed that foreign intelligence services, with their own interest to feed or national interest to feed, will continue to make sure that at least they manifest hostile operations to the disadvantage of South Africa, and that they actually make sure that they steal intelligence and any information of the South African state to advance their own cause. So I thought it's important that, particularly when we have to deal with this whole surveillance notification, we need to really draw it back home so that at least we all are reading from the same script. When we actually maintain or contribute as national intelligence toward the maintenance of national security, we do so to at least accommodate all South Africans, not only advocacy groups that must actually be allowed to exercise as and when they wish, particularly the right to privacy, but all South Africans deserve the rights to privacy. So, Chairperson, thank you very much for allowing us to share with you our perspective and the point of premise and what motivates us to at least want to, be allowed to at least execute our mandate effectively. Thank you very much.
Thank you very much, Acting DG and the team from SSA. Members, can we now interact through a show of hands with the presentation? So we'll get Honorable Breitenbach, Honorable Swart, and Honorable Mohlala. In that order, Honorable Breitenbach.
Thank you, Chair, and good morning to you. If you don't mind, I won't switch on my video. My connection's not great.
Okay.
So I'm a little worried about this presentation. Let me start with the apology for it being late. To receive the presentation at 9 o'clock for a 9:30 meeting is not acceptable. It's not helpful. And it does mean that all the members of the committee were unable to read the presentation and engage with it and think about it before it was made. I'm not sure if that was done on purpose. And an apology for submitting it late is not an explanation for why it was late. And we have no explanation for why it was late. There's been more than sufficient time to prepare a presentation, possibly a better one than this one, and to submit it in time for members to engage with it. So I find the entire approach in that regard disappointing and unacceptable. As far as the presentation is concerned, I have serious concerns about the presentation. I find the presentation to be, and I'll say this with the greatest of respect, to be superficial and somewhat puerile. It does not address the issues. What we're grappling with here are serious constitutional concerns that the committee was warned about already in the last administration, about the protection of personal security, about the protection of personal rights, about things that our constitution requires us to take seriously. Not even to mention that the Amabungane judgment was years ago, and many years have passed, so that a proper, comprehensive draft of legislation can be prepared to deal with all of these issues, instead of this stopgap measure that we're now trying to hammer into place. What we're trying to do now is to stick a very small sticking plaster over a gaping wound, and it's not helpful. And there appears to be no progress, no will, no intention of dealing comprehensively with this issue in proper legislation. And so I find this presentation to be wholly inadequate, again, with respect. To hammer on about how important state security is to preach to the converted. We're all members of parliament. We all know how important state security is. We all know that it's very important to have surveillance capabilities. We also know that it's very important to have proper control over those surveillance capabilities, and we've learned that from our very recent past. So to hammer on and on about how important it is for the state security agency to have the ability to, and the security agencies to have the ability to intercept and to surveil and to do their job, we know that. And we agree with it, and we want them to be able to do their job. What we want them to do is to be able to do their job in a constitutionally compliant manner. And that point seems to have been missed in this presentation, in my view. I'm also concerned about the suggestion that there's an exception made for national security by the court. I could find no such exception made in the judgment, but perhaps I've misread something. And if I could be pointed to it, I'd be very grateful. So that is my comment and my questions. And I must say that I was looking forward to this presentation, and I'm disappointed that I don't appear to have benefited very much from it. Thank you.
Thank you, Honorable Swart.
Good morning, Chair. I just greet you and the members and the representatives from SSA and the OIC. I'm going to turn my camera off with your permission. Chair, yes, I must say I share my colleagues' deep concerns about the presentation. Firstly, the fact that it has been presented so late. I don't think the explanation is satisfactory, that the Minister in the Presidency was not able to give the green light. I think these matters have been coming a long time, and we still do not have a satisfactory explanation. And Chair, I want to repeat my request at the last meeting that we want someone from the Presidency to come and explain this unacceptable delay in the processing of the legislation that we were urgently asked to pass, the stopgate legislation that we were urgently asked to pass following this judgment, which we finalized it on the 13th of December 2023. It was sent to the Presidency with the cutoff date, the 3rd of February 2024. It's now a year later. So for a year, we've sat without a designated judge. We've had in the submission very dire consequences of that gap in the law, very, very severe consequences of security, references to Mozambique, references to very serious implications. And we still do not have a sufficient and satisfactory explanation from the Presidency why it took a number of months, 9 months, until the matter was referred back to Parliament in November. I want specifically now to the SSA and to the department representatives, knowing that there was this gap from the 3rd of February 2024, what steps did they take to emphasize to the Presidency that there was a gap in the law that severely impacted the surveillance abilities of the SSA, and let us not forget crime intelligence, as there was no designated judge. What steps was taken to warn and to take steps? And was there any satisfactory response to that? Because it can't be that you just sit back and say, no, we'll wait. And the Presidency eventually in November refers it back to Parliament. So the point that is made about the delay in the finalization of this minimalist bill is squarely in the hands of the Presidency. And we need an explanation. And we have to date not had that explanation. I also want to ask the SSA, was this gap brought to the attention of any oversight bodies? We as Justice were not aware of it. Maybe we should have. But the Joint Standing Committee on Intelligence, was it brought to their attention? Because whilst I agree with my colleague about the submission, at least it does set out the severe implications of the delay in the bill. This very, very severe implications. And we need an explanation. And yes, whilst we appreciate, and as my colleague indicated, We appreciate national security. We appreciate the need for that. We all in agreement that the threats are increasing. And reference was made to Mozambique and terrorism-related matters. Reference was made to the grey listing. We're in agreement with that. But let us not forget that the Constitutional Court also highlighted the abuses that have taken place. The abuses by crime intelligence in the matters there. And that's got to be balanced. And that is why there was the balance with the right of privacy to ensure that there are sufficient safeguards and controls to bring the bill, make it more constitutional, make it compliant, because of the very abuses that took place and because of the fact that the designated judge, as the court said, is not in a position to verify the facts and relies on ex parte applications. And that's why these controls were set in motion. So, Chairperson, with those few comments, I would like a response on that. And yes, we're now sitting, that is exercise of oversight. Why were we allowed? Why was SSA allowed into the situation? Why were crime intelligence without the bill being finalized? Now we're sitting with the situation going forward. How are we going to remedy the situation? First step is the Constitutional Court application that sets out the severe implications of the gap in the law. That's the one step. Will the judgment come out quickly? Will it be retrospective as is requested? Then us dealing with this legislation. We're going to need time now to go through this presentation because it was only presented to us very late, and to evaluate to what degree does the department and this presentation accord with what the president is saying, and to what degree are we in agreement as legislators with what the approach is recommended, considering that we have to balance national security issues with the right to privacy as set out in the Constitutional Court. Thank you, Chairperson.
Thank you, Honorable Mshala.
No, thanks so much, Chairperson. Let me take an opportunity and greet members of the Portfolio Committee. And let me just say, in order to avoid the issue of time.
Honorable Mshala. Honorable Mshala.
Chairperson, can you hear me?
Yes, could you please
Am I
switch
audible now?
Could you please switch off your video for better coverage? You were cutting. Yes.
Okay. Am I audible now?
Yes, you are.
Okay. No, I say thanks so much, Chairperson. Let me take an opportunity and greet members of the Portfolio Committee. And let me just say protocol observed in order to avoid the issue of time and to save the issue of time. Chair, I'm Honorable Rebecca Mohlala, a member of the Economic Freedom Fighters. I will also want to join my colleagues in terms of the issue of documents that we received this morning. It's really out of order, and it deprived us to come with good engagements to assist this committee going forward. I really don't understand when they say they were waiting for the minister to give approval. We are holding the minister accountable in this regard. How can the minister then hold the documents and release documents when she wants to release those documents? She only released the document this morning, meaning that she did not want us to give fruitful engagement in this regard. Chairperson, I'm moving from that. I'm going straight now to the presentation. The agency says that they are willing, they are saying that the retention of Section 25A, subsection 2B, must remain in the bill to protect national security and uphold the right to life and security of the person. And then they further mentioned that the designated judge should have the power to indefinitely withhold notification if it would jeopardize national security. Chairperson, I really skeptical about the vague definitions that allow the state to use national security as a shield for political repression. Chairperson, we are requesting that the national security be clearly defined to prevent misuse against activists, journalists, and opposition members. We saw that happening before, where the state used its power to suppress people that have dissenting views over what they stand for. The other thing, Chairperson, the clause that allows indefinite withholding of notification. We need a strict limit of 2 years or even less than that, after which notification must be mandatory, unless a judge provides a well-justified extension reviewed every 6 months, because we saw cases delaying until we don't get anything of what is happening on those cases. I mean, justice delayed is justice denied. We must not allow those things of taking 2 years, a person being under surveillance, nothing is happening, and at the end of the day, they are actually occupying the space of that person. What about the privacy of that person to that extent? Chairperson, we also actually, I also think that the bill must prioritize the economic security of South African. We must not just speak about the national security focused on terrorism and spies, but not on illicit financial flows, corporate lootings, and economic sabotage. I think those things as well form part of our national security. They must also be mentioned there. We need a stronger oversight mechanism to prevent abuses by intelligence agencies, including a judicial review committee that reports to Parliament. Those are the things that I think the bill must also address. The issue of appointing one judge, we are also very skeptical about that, because we need a committee that is going to be independent. One person is easy for the person to be partisan. We don't need people that are partisan here. We saw that happening before, where judges just take very wrong decisions, and there's nothing that we can do about that. And who's also appointing this retired judge and all those things. So Chairperson, let me end there. Thanks so much.
Thank you, Honorable Nomvalo.
Yeah, thank you very much, Chairperson. Let me join my fellow committee members in expressing my deepest discontent on the failure to share the presentation on time. I'm not saying this because I'm in a mood of singing with everybody, but just to put an emphasis and also to remind the SSA that if you undermine this committee, then you are going to have a problem. Reports here, there are time frames. You don't send a report on the day of a meeting. And also, Chair, my deepest discontent goes to the unavailability of the minister from the presidency, because here we are discussing concerns which have been shared by the presidency. And some explanations maybe were supposed to be given from that office. Now, there's nobody who's available here to represent the office of the president. And I think we should not take that lightly, because it's the presidency that is raising concerns. So I just want to register those two concerns before I go to the report briefly. My first point on the report, Chair, one is about the lack of trust by the members of the public to the intelligence of South Africa. And it's not just an over-exaggerated mistrust, but it's there, and it has been orchestrated by the failure
of the intelligence of South Africa in many instances. Sometimes the people will be ahead of the intelligence. You know, there are many incidents. You know, when a person decides to hire protectors, it's because they've detected some threats, and most of them take those threats to the police. They report them to the police. But in many instances, some end up dying because the police have not been able to detect any threat against, those people. I mean, I can safely talk about the case of Sindiso Makaka, which is prominent in the public domain because I know it at a close range that he hired, personal protectors because he detected some threats, against his life, and he reported such to the police, but he was failed by the state. And the Sindiso Makaka case is a reflection of many cases, of that nature, wherein the citizens are purely failed by the state. So I'm saying we have as a party that I represent here in Parliament, we have a serious, lack of confidence towards the intelligence of South Africa. And also the July unrest. If we had a proactive intelligence in South Africa, would not have occurred. The reason why it occurred is because we did not have intelligence. I think we must agree in that regard that we don't have intelligence. And I'm tempted to ask if, with regards to the law that was in possession at that time, were they not able to detect the July unrest because of the lack of capacity of the personnel or because of the lacuna in law? I wanted to ask that question. What led? I know that it belongs to the previous administration. Maybe the matter was dealt with sufficiently. But I'm saying, we need to identify the mission adequately and clearly so that when we deal with the law in question, we know that what is it that we seek to address and what is it that we seek to defeat in terms of putting proper laws in place. But in terms of the recommendations, Chair, I agree with the recommendations that they are proposing in relation to assigning a judge that will deal, with these matters. But subsequent to that, I think the circumstances under which surveillance notifications will be determined must also be regulated. They must not depend on the discretion of one person being called a judge, because we know how the judicial authority, has been abused in this country. So we can't open further loopholes. A judge must know that to determine whether here the post-surveillance notification must be applied or not, these are the circumstances that I must consider. So the act must not be vague. I mean, the bill must not be vague in that regard. It must, outline them vividly. So those are the submissions, Chair. We don't have anything much to submit today, except to discourage what these comrades have done to us, this injustice, that it must never take place again. Thank you very much. Thank you, Honorable Dana.
Thank you, Chair. Good morning to everyone. And I dare say thank you for the presentation, Chair. I fell off for a minute, so I'm not sure if I'm repeating something that my colleagues have said, but nevertheless, I think it's important then that it be repeated. First of all, I don't know if it's because we didn't receive the presentation in time or if I missed it, but I don't think the constitutional compliance issue is really addressed in the presentation. It was unclear to me. I'm tempted to say it wasn't addressed at all, but let's just say it wasn't satisfactorily addressed. That's the first thing. So I'd like more information on that, please. Secondly, and I know now I'm repeating some of my colleagues' concerns, but it's unacceptable that we receive this presentation so late. This is an issue pertaining to our constitutional protection, and I wonder, was it on purpose, or is it just an attitude that you don't really care about what the Portfolio Committee on Justice think? Because I really hope it was rather on purpose then. Because this is a very important issue, and it really is unacceptable that we receive this presentation only half an hour before the meeting. It seems set up, and I'm sure if you could get it half an hour before the meeting, then you could have gotten it yesterday or the day before. So that is some of my concerns, Chair. And then I would like to agree with Honourable Swartz that we do get someone from the presidency to come and explain the delay. It's not the first time that something like this is delayed. There are many delays coming from the presidency, and I think that it's important that this be addressed to us. Thank you, Chair. That's all for now.
Thank you, Honorable Glover.
Thank you, Chairperson. Please indulge that I leave my camera off for the same reasons of bandwidth. Chairperson, my submission is actually very short. What worries me in this matter is that it's been idling for extremely long. Over a year, it was just sitting there waiting to be addressed. And all this, while the possible threats that the country is exposed to, I mean, we've heard today submissions of terrorism, espionage, hostile attacks, possibilities of that, increased attacks, reduced intelligence, weakened counterterrorism efforts, global security, public safety concerns, and the list carries on. And this was made in the submissions today. What my question is actually quite simple, Chairperson. What did the SSA do in the interim to create an urgency to this matter? Considering it stayed for a year, was there any interventions at any point? And I think this is so important because knowing full and well what the impact of this bill not being attended to was, why did it take so long? Was there any measures taken in between to actually address that? You know, a year, well, the many years that it's been in taking, it's unacceptable. This is the direct work of the SSA. So I would just like to know what was their interventions in between. Thank you, Chair.
Thank you very much, members, for the interactions. Acting DG, can we make interactions or reactions to the issues raised by members? Acting DG?
Thank you very much, Chairperson. We accept and really again profusely apologize for sending the document and the presentation late. It was not out of ill intention or anything intended to actually deprive members, honorable members of parliament, time and space to really interact with the document and the presentation. As I've said, we needed a green light from the minister because matters of legislation and policy belongs there. We are only implementers of policy. We are operational people. And when matters of legislation are brought to our attention, we refer them first to the minister. But on the whole, we again profusely apologize. Again, Chairperson, with all humility, I think the problem of South Africa is the notion that national security is the preserve of state security agencies, and that state security agencies are there to use national security as an excuse to suppress the rights of people. If we were to at least go and interact with Section 198 of the Constitution, Chapter 11, and if we go and interact with the pronouncement in the white paper on intelligence, which talks to the doctrine, we will realize that national security is the responsibility of everyone, including the legislature or lawmakers, the judiciary, the executive, all South Africans. And that at least what is the preserve of state security agency is intelligence. And that intelligence will actually be exploited or procured in a manner that does not actually undermine the privacy or the Bill of Rights that are enjoyed by South Africans as reflected in Chapter 2 of the Constitution. We mean no harm. In fact, I'll even venture to say there are oversight mechanisms, sufficient oversight mechanisms that are constitutionally enshrined, like Section 199 of the Constitution. The Auditor General, the Inspector General of Intelligence, the Joint Standing Committee on Intelligence, there are quite enough oversight mechanisms. And there are also internal governance mechanisms that make sure that intelligence is not procured in a manner that actually infringes on the rights of people. So to state that national security when applied or executed will actually be contrary to the spirit, the purport, and the object of the Bill of Rights, it's misplaced. We are indeed of the same view that there have to be constraints so that intelligence collectors and investigators, including analysts, must not abuse these privileges. So we are in agreement on constraining the way in which intelligence actually works. We are constitutionally compliant. All we need is to at least be allowed by lawmakers, as they have actually in years gone by, promulgated legislation to provide mandates to us. You see, what is of concern in South Africa is that statutory agencies are actually constrained. There are sufficient oversight mechanisms, but private intelligence firms and private security companies that are actually using the same or even more of the equipment that indulge in or intrude in the privacy of South Africans are not actually brought to book. This is what actually sometimes boggles one's mind, that we talk about constraining security agencies of the state, but therefore allow private intelligence and private security firms to continue doing things with no oversight. And that is a worrying part. And that is really a worrying part. On issues that are relating to the work of the OIC, I will ask Chairperson, if you will, Kumbula to Mr. Masinga to actually reflect on that. But we really share and in the concerns raised by the honorable members of parliament in terms of making sure that we indeed balance secrecy with transparency. And we really want at least to urge honorable members to really agree national security is their responsibility, not only responsibility of state security agencies, and that intelligence only contribute towards maintaining national security. As I said, Chairperson, 3 goals of national security. 1 is to guarantee the existential continuum of South Africa. And 2 is to express the reason of the South African state, which is national interest. And 3, it is to at least actualize the very resolve that is articulated very well in Section 198 of the Constitution, which provides that national security is the resolve of South Africans as individuals and as a nation to live in peace and harmony, and to be prevented or protected from fear and want, and to live a better life. Now that section is very mindful, and that section can make national security or the maintenance of national security a constitutional imperative. So what is then left to intelligence agencies is to make sure that as and when they execute their responsibilities, they observe that Section 198 and they observe Section 199 and do their work efficiently and effectively to the extent that what is pronounced or what is provided in Section 198 is what indeed South Africans enjoy. What is provided in Chapter 2 of the Constitution, which is the Bill of Rights, is indeed what South Africans have to enjoy. There is also Section 36 of the Constitution, the limitation clause, which also provides some kind of oversight mechanism in the whole work of the intelligence community in South Africa. So I want to believe that South African intelligence agencies are sufficiently regulated. What is not regulated in South Africa, and that is one thing we should be talking about, is the private security and intelligence firms that have actually been responsible for producing subversive material and political material, and when the popo hit the fan, attribute that to South African intelligence community. And that is what we should be talking about, because these are the people who are responsible for abuses of these technologies or intrusive measures that South Africans find themselves being trapped in. Chairperson, I would really ask that you Honorable Chairperson, that you allow us to have Mr. Masinga to reflect on what transpired when we took so long that we addressed this issue, the lacuna issue. Mr. Masinga.
Thank you, Mr. Masinga.
Yeah, thank you, Chairperson, and thank you, DG. I think the issue around the interventions that from the OIC embarked on, maybe let me just start by saying, firstly, we were part of the RICA, comprehensive RICA review process that is led by Department of Justice. That was looking at holistically reviewing RICA, that was done with the understanding that the current bill that is there, which is minimalistic, is not addressing all the issues. So this matter of the bill being with the president has always been on the radar of our executive. On an annual basis, we as the OIC, we do submit our reports we're submitting our reports to the judge, designate judge, which is actually combined with the report of the judge going to the Joint Standing Committee on Intelligence, JSI. So the issue of the bill, which with a possible lacuna, was always flagged to say there is this consent that 36 months it's going to expire. It's going to expire in February 2024. We have been hammering this matter to say time is running out. Something needs to be done. we can only do up to a certain part. Even if you go to the report related to the JSCI, you are able to find the issue around the Constitutional Court judgment appearing even on the annual report of the JSCI. So I think a lot has been done in that area. Even the president is acknowledging there to say in the documents going to the Constitutional Court that is asking now for the Constitutional Court to read in again the orders that they have made before to extend the period, actually the validity period of the act, where he says it was a question of misinterpretation. But let me not dwell much in terms of what was the president's interpretation on this matter. The presidency will be able to answer to that properly. Just from our side, just to emphasize that a lot has been done in terms of really flagging that there is a concern in terms of the countdown on the period that was given. The other part that I wanted just to touch on, I think it was raised by Honorable Nomvao around the issue of what was there when the July unrest happened and so forth. Well, to a certain extent, this is a matter that possibly the police and the SSA can respond to, but I can just touch on in terms of the little contribution as the OIC to what was the contribution there. To a certain extent, I think since the RICA was still in place at that particular time, there were a lot of activities or maybe collection activities, I think that was utilized through RICA at that particular time to gather some information in terms of intelligence. You don't necessarily get the whole picture. You put puzzles together. So it's not easy to say a July unrest happened because there was a gap or maybe inefficiencies in terms of RICA. But on this matter, I will just refer back to the report, the expert report on the July unrest, civil unrest, I think as chaired by Professor S in Africa. It's giving us details. I think there was some level of accountability in terms of what happened, what transpired, what was the gap there. But at that particular time, I think the infrastructure in terms of surveillance was still effective. There might have been gaps that might have led to that. The other issues, acting DG, I think they were addressed. I see my colleague, Ms. Deneke, her hand is up to touch on some of the issues that I might have left out. I'll leave it at that. Thank you.
Thank you. Acting DG, are you done from your side?
Chairperson?
Chairperson, if you allow maybe Ms. Jenneke, Alfredine Jenneke, to make comments as well on our behalf.
Thank you, Mr. Alfredine. Proceed.
Thank you, Chairperson. Chairperson, it's deeply regretted that the committee has not had an opportunity to engage with the pre-presentation before it. And honestly, from our side, it was an unavoidable delay. There was certainly no intention to frustrate the work of the committee. And in that respect, Chairperson, even our presence at the committee was because we viewed the issues so serious. Admittedly, we did join the proceedings before this committee rather late, and our first appearance was here last week. Chairperson, at that time, you indicated to us clearly that all that was required of us for this presentation was to do an addendum for the presentation that Department of Justice and Constitutional Development had already made to you. You also specified to us that we were not supposed to, that we were only supposed to address three issues which had come up during the discussions at the committee last week. Those three issues are the key issues which preface this presentation, and it is the national security imperatives, the implications of post-surveillance notification for the agency, and the impact of the legislative lacuna created as a result of the delays in the enactment of the bill. Chairperson, you will remember that when you briefed us last week, you said clearly that you had hoped that we would just write up the comments that we had made during last week's discussion. And the Deputy Minister of Justice impressed that the agency was not supposed to address operational matters, because our concern was that the committee that provides oversight to the intelligence services is the Joint Standing Committee on Intelligence. And we were therefore at pains to say that our appearance before this committee was to support the work which Department of Justice and Constitutional Development had already done. And at the start of the presentation, I had introduced the presentation emphasizing that fact. Therefore, it was not expected of us to give a legal exegesis regarding the balancing of rights, as the honourable members had requested now during our discussions. But we take that in the spirit that the honourable members had not had an opportunity to engage with the bill. In fact, our view, and as we stated in the pre-presentation also, is that our initial response was to abide the application which was made by the President in the Constitutional Court, wherein he is seeking to extend the deeming provisions, the read-in provisions, which the Constitutional Court had ordered in 2021. But we have been asked to make submissions to the Constitutional Court, which we are in the process of drafting. And as my colleague, Mr. Masinga, has indicated, we are also in the process of engaging with Department of Justice and other affected stakeholders regarding the legal aspects of the draft bill and the comprehensive review of the entire RICA framework. So that being said, Chairperson, I must disagree vehemently with the honourable members that the bill is superficial. The bill was, that our presentation was superficial. It was in line with what our brief was from you last Tuesday. And that was all which the presentation had sought to achieve. So thank you, Chairperson, in that regard. Also, with regards to, as my colleague has intimated or alluded to, the President had made an application for condonation to the Constitutional Court. And his application for condonation essentially sets out what the grounds are for why the processing of the bill was delayed in the presidency. I don't think it's the remit of the agency to explain that, but we will communicate this to our minister, and also the fact that the committee is discontented with the delay. Thank you, Chairperson. That's all that I have to say.
Thank you very much to you all as the delegation of SSA. I see there is a hand of Honorable Mhlala. Honorable Mhlala is...
No,
Honorable...
thanks so much, Chair. It's just a follow-up question.
Okay.
Earlier when I was doing my inputs, I spoke about the monitoring of corporate financial crimes. I spoke about the surveillance powers must also be used to track illicit financial flows, the tax evasion and corporate frauds. Because the bill only speaks to terrorists, while we are allowing billionaires and multinational corporations to loot South Africa's economy. So my question is, I think they did not answer that. Who's monitoring these corporate financial crimes if we are not putting it under this bill. And another thing that I want to just add, Chairperson, is on this, the reviewing of RICA to strengthen control over SIM cards and surveillance abuse. The agency and the OIC says that the bill must include better control over SIM cards to prevent criminals from using unregistered numbers. So, Chairperson, and they also says that law enforcement must have stronger powers to monitor and investigate serious crimes. So my question is just, can we have a clear, maybe distinction in our bill between crime surveillance and political surveillance? Because law enforcement must be legally prohibited for targeting activists, journalists, and opposition members under the excuse of serious violent crime. So we need a clear distinction so that we can also understand how this thing will unfold. And lastly, Chair, the bill also spoke about the responsibility of service providers. And it further says that mobile network and service providers must implement a stricter know your client something to block unregistered SIM card and all those things. How do we ensure that this is not abused, Chairperson? The stricter SIM card regulation but demands that any penalties employed on service providers must not lead to higher cost for consumers. The government must ensure no private companies allowed to gain profit from new surveillance regulation at the expense of the poorest masses of the people. With also international cooperations also being monitored. The surveillance law apply equally to foreign. Is it possible for the surveillance law to apply equally to foreign companies operating in South Africa? The question is, why should Vodacom and MTN be forced to monitor ordinary people while multinational corporations are not held accountable for financial crimes? Thanks so much.
Thank you. Acting DG, any quick bite on that?
Thank you, Chairperson. I will ask Kumbula and Ms. Denica to at least make some comments in relation to what Honorable Mushala has just raised. Safe to say, Chairperson, we might have used terrorism as a matter that needs serious attention. But the law that provides us with the mandate, that is Act 39 of 1994, amended, gives us the responsibility to look at hostile manifestation that amount to acts of subversion, sabotage, treason, terrorism, including proliferation of weapons of mass destruction and corruption. And that is the act that defines counterintelligence responsibility, which is the domain of the domestic structure of the state security agency. In that very definition, economic crimes are included. So it's not only terrorism. Economic crimes are included. Whether they are actually manifested in South Africa or transnationally, they become matters that needs to preoccupy the work of the domestic branch, the counterintelligence structure of the state security agency. And I want to believe that that will, in actual fact, address what Honorable Mushala is actually concerned about. We in the process look into economic crimes as matters defined within the context of implementing the counterintelligence responsibility. We do not actually delve, let me rather say, Section 199 of the Constitution is very clear. It is very clear that security agencies are not allowed to prejudice or to promote political activities of any party. Legitimate political activities of any party is promoted in terms of the Constitution, and Section 199 is very clear on us, and we observe this to the latter. I must say to honorable members that a lot is said about intelligence in South Africa. The unfortunate part is that we sometimes seem to have no right of reply, and we agree to that. But a lot is attributed to intelligence in terms of abuses when it is not supposed to be in our doorstep. When this is actually done by private individuals, private security firms, and private intelligence firms, those entities that we are not actually paying attention to. And we know it because one of the responsibilities that we have is to monitor such entities. And we know for a fact that they are responsible for abuses of private or for privacy of people, and let me rather say the right of privacy by South Africans. If you can allow us, can we have Ms. Jenica and Masinga to just comment on the technical issues?
Okay.
Thank you, Chair, and thank you, DG. Let me start by the few technical issues that Honorable Mushala raised. The first one around the issue of the SIM cards. Well, the challenge that we are experiencing related to unregistered SIM cards, it's a serious concern. Actually, I'm not putting correct. I'm saying unregistered SIM cards, but they are registered. It's only that they're not properly registered. This is a matter that we have been engaging the mobile network operators and say we are having these concerns. This needs to be addressed. Other countries, they've addressed it differently in terms of fines. I think we know the case of MTN in Nigeria's story. We have been engaging on this matter to say this is creating a problem for our investigators because they will identify a number. It's known that this target is using this number, but when you go and check the ownership, you realize that that is not the name that is associated with that number, which is a problem for the judge to give you a direction or an approval on a name that is not associated with the number, a number that is used by a specific target. So it's an issue that must be addressed. And this is currently addressed through the comprehensive RICA review process to say, let's tighten that area. Let's tighten to make sure that we have means. To a certain extent that, or maybe let me not dwell on the thinking for now. Let me just leave it and say the comprehensive review of RICA needs to address that part in terms of the SIM cards. It goes to the point in terms of knowing your customer issue that we are also, it was part of the recommendation as it was presented, know your client, which it's used in different countries, and other countries, they don't even do it because it's a legal requirement. They do it because to them, it gives them a competitive advantage to say, once you know your customer, like what retail does, they are able even to tell you that actually, because we know you, the amount of sugar that you have at home is almost depleted. Maybe we should send a delivery to bring you a replenishment. You know, that those are mechanisms to find a way of saying, I know our customer, we know their preferences and so forth. So in other countries, they're able to do that. But it's useful as well to address even some issues that we're experiencing around the registration of SIM cards. The other aspect to the question that was raised related to the grounds that needs to be covered, illicit economy, tax evasion, and so forth. When we presented earlier, we did indicate that the stakeholders that are currently using RICA include SSA, police, defense. You have entities like your FIC, Financial Intelligence Center, that is also part of the entities that's supposed to use the very same bill we're discussing. And as the honorable members are aware that there was the omnibus bill, what's called the omnibus bill, the anti-money laundering and combating terrorism financial amendment bill. That omnibus bill is basically looking to some of the aspects related to the financial and economic related matters, because it seeks to amend the figure as we know it, and then even the Trust Property Control Act and so forth. So the omnibus bill, it's looking at that to say, which was passed by Parliament somewhere around the 2022, if my memory serves me well. It might be going through various stages. I'm not sure where it is now. But that bill will be looking at allocating various mandates to different entities to say, you are part of law enforcement, or you are given this responsibility. Your responsibilities to look at money laundering and so forth. So the grounds in terms of illicit economy and the tax evasion is given to a particular entity by a particular piece of legislation. That entity, in this case, FIC, it's allowed to use RICA through the OIC to apply to the very same judge in terms of what we're discussing now, to get the content or whatever information of surveillance that they require to assist them to address that challenge that they might be experiencing in that part. I think that is the few technical issues that I should respond to, and then hand over to Ms. Jenneke to address other issues. I'm aware that we might not be addressing everything in detail, because some of the issues, there is a comprehensive RICA review process that's supposed to be looking at that. Earlier on, Honorable Mhlala also touched on the issue of limiting of the period for post-notification. Yes, the reason now we're having this discussion and the President has referred back this RICA bill, amendment bill to Parliament is because he's concerned about the very same issue. To say if ever a judge can have this, maybe the period can go forever, it creates a problem. So this committee or Parliament will be seized with this issue to discuss, to say which one is better. we are arguing that there must be an opportunity to not notify. But we need to find each other to say what will be the balancing ground on this aspect. So this matter, basically, it's an issue that the committee will be seized with in the next few weeks and few months, if I'm not mistaken. Acting DG, thank you. Let me hand over to Ms. Jenega or any other member of our delegation who might have a contribution. Thank you.
Thank you, Chairperson. Chairperson, just to augment the contribution by Mr. Masinga, we are speaking specifically about the Financial Intelligence Center Act 2001, which would gather information and intelligence regarding financial flows, illicit financial flows. So that's the applicable legislative framework here. And then with regards to the issue of raised by the honourable member regarding crime versus political surveillance, I think the definition of national security as contained in the National Strategic Intelligence Act, and which was formulated by this House, specifically excludes in the definition of national security any lawful political activity, advocacy, protest, or dissent. So that's in the definition of national security, and therefore the agency would not or should not intercept the conversations of politicians and that have political significance. With regards to oversight, those complaints of that nature, where such complaints are made, they are referred to the Office of the Inspector General of Intelligence, and the agency, even in last year, has ongoing engagement with the Inspector General of Intelligence regarding interceptions and the way that they are conducted. Thank you, Chairperson. I think, Chairperson, if there are any, my proposal is that if we have missed out on any of the questions, if the committee secretariat could be so kind, if they require further explanation, the explanation can be provided in writing, in case we have missed anything, but I think I'm covered by the input. Thank you.
Thank you very much. I think beyond the fact that we received the report late, which is an unacceptable way of working, part of what has been quite a problem for us as the committee is actually communication. Was as when I conducted the committee secretary yesterday asking where is the presentation from SSA. At that time, we couldn't even find the PLO, so that we were able to understand this frustration that you have experienced for submitting the report in time. So had communication been effective, it would have been better, because we would have understood the frustrations that we are experiencing in regard to submitting the presentation in time. So it's something that I think you have learned from, so that you are able to make redress to it and ensure that whenever you're appearing in Parliament, even if it's not specifically justice, when you are appearing in Parliament, you are able to send presentation in time so that Parliament is able to prepare itself for your presentation, because it becomes fruitless when we have not interacted with your presentation before the actual meeting. So I think let's take that as a lesson for today, which must not be repeated. I think, members, we are going to have ample time for a committee meeting to deal with the actual substantial issues of the bill. Now, I think what has been of particular importance was now that the bill has been remitted by President, how do we move forward? What are the issues there relating to that? But we'll still have time to deal with issues of substance of the bill, including the proposals by SSA and by both SSA and the Department of Justice and Constitutional Development of retention of Section 25A. Issues relating to whether we have one designated judge or we have a panel of judges, or we have one designated review judge, or we have a panel of judges, and all relative substantial issues relating to the bill. We still are going to attend to them as the committee, as we'll be working onto this bill. We have had a problem of an unreadiness of the Parliament Legal Unit, for they were supposed to have given us their legal opinion in the last Friday, but they did indicate in time that they will be unable to meet the time. So, but they commit that they are going to be able to draft and prepare something for the consumption of the committee. So we are going to receive them as well in a date agreed upon between ourselves and them, so that we're able, therefore, to give a direction of what then must happen. Because you'll remember, they are the ones who came to a committee meeting and firmly argued that we must write to the president and seek more clarification on the reservations in line with the Rule 235 of the Joint Rules of Parliament. So we really will need their input to guide us and actually help us arrive at a decision of what then is the next step the committee is taking. So we will call them again in a date that which we have agreed upon. So for now, we'll leave it there. We'll take the presentations, all of them, the three of them, as one of the guiding documents that we are going to use in ensuring that we arrive at a correct decision, a decision that will not compromise even the legality, and ensure that the bill meets the constitutional muster. So until then, we'll have a meeting that will deliberate on the next step that the committee will take. Members will recall that there were numerous steps that were presented by the content advisor in the last meeting regarding this matter. So we are going to give consideration even to those, then pave a way forward. Yes, of course, all the presentations that have been submitted to us from the Department of Justice, SSA, the legal unit, the Parliamentary Legal Services Unit, are not a gospel truth presentations, if I may say it like that. They are documents that are meant for us to interact. They are documents that we are actually in liberty to agree with parts of the governments or disagree with part of the other governments. We're not bound to take everything that is presented before us as a way forward, but they are helping and guiding instruments that are going to help us moving forward in the journey of amending the RICA bill. So we are at liberty really to have some to raise some issues relating to the presentations, the recommendations, and everything else. So for now, we'll take it from there. We'll have a deliberation on everything that has been submitted and pave a way forward, and inform the speaker of what the committee would have agreed upon. Because even if we say we seek more clarification from President, we can do that through the Office of the Speaker. So, members, for now, we'll leave it there. The only issue that I think I must highlight is we're supposed to be going to the South African Human Rights Commission head office by Thursday. It has come to light that they have long planned to convene a strategic planning of the institution. And upon interacting with that, we have found that there's a lot of services that they have already paid as the commission. So it would be very irresponsible of the committee to instruct them to or expect them to withdraw everything and attend to matters relating to our oversight visit. For we know the financial struggles of that institution, and for we know the budget that we approve for that institution does not have that kind of leverage. And we know the AG's concerns about how fruitless and in the care service. So with that, we have then looked at an appropriate available date in line with the meetings that we have for next week. So we thought Friday next week will be an appropriate date because we have we have physical meetings Tuesday next week and Wednesday next week of annual reports. So we'll then depart on Thursday, the next day after the last meeting of the week, and conduct our oversight on Friday, the 28th. Then after that, we'll disperse. Members, thank you very much for coming here in this meeting and interacted with this bill that with this presentation that will enable us to attend to issues relating to the Barika bill. I've seen in the meeting that there is also officials from the Department of Justice and Constitutional Development. We thank them for coming so that if anything arises out of the interactions, they're able to give particular responses to such issues. SSA, thank you very much for your presentation. We'll take it as one of the documents that are going to guide the next step of the committee. We thank you very much. With that being said, members, the meeting has come to an end and it is adjourned. Thank you.
Thank you.
Good job.
Thank you, Chairperson. Goodbye.
Recording stopped.